What's up, guys? This is Mr. Eldridge, and today we're going to look at the next step in our Period 3 key concepts, specifically looking at the creation of a stable government and how the United States moved to the United States Constitution and away from the Articles of Confederation. So the first attempt at unifying the colonies into a single constitutional republic were the Articles of Confederation, which was established in 1781 and will officially be replaced by the United States Constitution after the ratification of the Constitution in 1789. The Articles government was a confederacy. This is one that gives most of the power and authority to the states rather than having a real true central government. The fear of a recurring tyranny led them to this point. The drafters intentionally created a weak central government, but they found out early on that this moment required something different. They found out that this government was ineffective. So one of the great examples of this was that the Articles of Confederation did not allow for the imposition of taxes. It did not allow for a central government to create treaties. It did not allow for the settling of disputes with Native Americans or commanding a standing national army. And so it is because of this that you're going to have a major situation occur, and it showed that there is a need for a constitution. Each state is going to act almost as an independent country with their own agreements, trade regulations, policies, currencies, and the like. And so state courts began to confiscate land from defaulting farmers in western Massachusetts. And Daniel Shays is going to lead a rebellion against the state, and the federal government was unable to stop it. It had humiliatingly relied on state and privately funded militias to stop this Shays rebellion, if you will. And so it becomes a need. It becomes, there must be another form of government. We need to fix the Articles. And then what they find out is that there is no fixing the Articles of Confederation, but rather that they need to come along with a new constitution. State officials met to reform the Articles in 1787, specifically in the summer of 1787. Early on, there were two groups that met, Pennsylvania and Virginia. And early on, it was glaringly obvious that there was no fixing the Articles. The meeting quickly turned into a constitutional convention in which the Articles themselves were abandoned in favor of an entirely new government, what we call today the United States Constitution. What they established in the summer of 1787 was a federation, if you will. A union of particularly and partially self-governing states that were under the authority of a central federal government. Among those who intended to reform the government with a stronger national government were most notably Alexander Hamilton and James Madison. Of course, James Madison is going to have the moniker of being the father of the Constitution because of his meticulous notes that he kept. Those agreed with Hamilton and Madison's general position were later referred to as Federalists due to their desire for a stronger national government. Those who resisted changes that deferred to state power to national power, most notably due to fears of tyrannical executive rule through the presidency and the judicial branch, were known as your anti-federalists. Those included Patrick Henry, Thomas Jefferson, Samuel Adams, George Mason, and others. Many of these anti-federalists will not sign the Constitution, this newly minted document. All members agreed the government should be modeled according to Montesquieu's separation of powers, with the United States Congress serving as the head of the legislative branch, the President of the United States serving as the head of the executive branch, and the Supreme Court of the United States as the head of the judicial branch. Legislatively, you're going to have a formation of two entities, what we call the Congress of the United States of America. You have, of course, the Senate, and you have the House of Representatives. It was undecided on how to appropriate the two houses in this bicameral institution. Much of the early debates was trying to decide how that was going to be. So the idea was that the House of Representatives would act as the lower house, if you will, elected directly by the people, and that the Senate would serve as the upper house, elected by state legislatures rather than directly by the people. Now, we are going to see later on how that is going to change, specifically with the 17th Amendment to the United States Constitution. In these debates, Virginia came up with a plan to determine the number of representatives each state had. The larger states, such as Virginia, Massachusetts, and Pennsylvania, they wanted to have a plan which was based on the number of representatives on state population. Most states, particularly the smaller states of New Jersey, Rhode Island, and Delaware, they tended to support William Patterson's New Jersey plan, which proposed an equal number of representatives or votes for each state. And so we see that the Virginia plan had little chance of success until it won the support of the southern slave states by proposing the 3/5 compromise, which says that 60% of slaves in those southern states would count towards the representative total count. This proposal won over the slave states and secured an alliance between large and slave states to pursue the Virginia plan. It should also be noted as well that this new Constitution, especially what we know as Article 1 of the United States Constitution in regards to the legislative branch, would not have been accepted by southern states, including Georgia, North and South Carolina, as well as Virginia, without some form of acknowledgement or some compromise in regards to the institution of slavery. Despite the alliance between large states and slave states, there was still a stalemate. To make matters worse, smaller states such as Delaware threatened to leave the convention if the Virginia plan was passed. Hostilities were eventually stopped, however, by a compromise proposed by several delegates from Connecticut. And it's also what we refer to as either the Connecticut Plan or the Great Compromise. The Senate would be a fixed equal number of representatives, and the House would be determined based on proportional representation. Senators would vote individually by their own conscience rather than as blocks that were determined by state legislatures. This freed the National Congress from state influence. The vote passed as both parties were relatively satisfied. This great compromise received only part of what they desired. And that desire, of course, deals with the rights of states. To finalize the power of the legislature, you have the Supremacy Clause, which firmly placed federal congressional authority above state legislatures and authorities by official, making the Constitution the supreme law of the land. And it's with this that you have the ratification of the United States Constitution. Now, it is going to take 2 years for that to take place. They approve in the summer of 1787, but the actual ratification of the Constitution does not happen until 1789. There are going to be certain mechanisms in regards to this newly formed document. To prevent a runaway federal government, there was a system of checks and balances created to limit the power of a given branch by providing checks for each other, power over those. And you can see now on the screen this chart that shows us some of those checks. Another critical component in drafting the United States Constitution was the inclusion of an amendment system, which allowed revisions to be made as unforeseen issues emerged. And through the years, we have seen countless amendments, including the right to allow women to vote. You get into the prohibition of alcohol and then the repeal of that, the changing of the voting age, and others. The Constitution requires that for states to change the Constitution, 2/3 of the state legislatures must submit a request to Congress for a convention. To make it change, 3/4 of the states must approve in order for the Constitution to be changed. For states to change the Constitution, 2/3 of the state legislatures must submit a request to Congress for a convention. To make a change, 3/4 of a state ratifying convention must agree to the implementation of this change. Another method required is that 2/3 votes of Congress to propose an amendment. To implement the change, 3/4 of the vote for state legislatures must be obtained. By providing these two routes to amend the Constitution, it ensured that the federal government could not change the government without the consent of 3/4 of the states. It also provided a solely state pathway to change the Constitution. So finally, after the creation of the Constitution, anti-federalists were still unhappy. The feeling was that this document was too powerful for the federal government. They wanted to have certain inalienable rights that could not be taken away. And so, in order to bring along some of the southern states that did not approve, especially these anti-federalists, you have the creation of the Bill of Rights. There was a concern in regards to the idea of judicial review. This ability to void actions as unconstitutional. Hamilton argued in Federalist Paper 78 that the judicial branch was constrained to exercises and its powers only according to the Constitution. He also noted that lifetime judicial terms were conditionally based on good behavior. He literally used all capital letters to emphasize this point, and that this stipulation allowed the impeachment process to corral any out-of-control justices. Despite his points, many states were still concerned that the powers of the judicial branch were too vague, and that there was a substantial amount of legal wiggle room that judges and or justices could use to abuse citizens and states. See the Brutus Papers. They show how the concern was there amongst anti-federalists. And so to appease these states, in Congress, Madison drafted and proposed 12 amendments that addressed their concerns. 10 of these were ratified by 1791. These 10 amendments are collectively known, of course, as the Bill of Rights, and have protected the rights of states and individuals against the courts and federal government, as well as serving as a stepping stone for the expansion of civil rights and civil liberties in the 19th, 20th, and 21st century. They've allowed for freedom of speech, religion, press, assembly, the right to bear arms, no unreasonable searches and seizures, the ability for protection in your homes, persons, papers, and effects, the right to have an attorney, the right to no excessive bail, the right to no cruel and unusual punishment, while serving and allowing for states to have autonomy for things that are not in the Constitution. Thank you so much for paying attention to this video. If you have not hit that subscribe button, please go ahead and do so now. Make sure you like this page. Thank you so much, and you have a great